We'll get started in just a second. This is Chris Loehr, and we appreciate you attending today's session for National Cybersecurity Awareness Month. Today's session, how and why to engage legal counsel during a cyber incident. We'll give people maybe a couple of minutes to attend, and then we'll go from there. Seeing my friend Wade Kilgore is on. He's usually always the last to show up, so maybe that's a good sign. So let me tell you a little story. If you hear a little bit of noise in the background, I apologize. So a little personal story. I have 5 kids and 2 boys sleep in one room. Well, the other day, one of my dogs decided to sleep in their room and the door was closed. And let's just say she, I guess the prior meal did not agree with her. And so I woke up to a smell in my house that I was not impressed with. So my kids went to school and I ended up tearing my son's room up, tore all the carpet out, took all the furniture out because I had to do that to get all the carpet out. And so my wife has been trying her best to get their room redone so they can sleep in their room and not out in random places in the house. So I apologize, but I think the doors are closed. But if you hear some grinding in the back, it's not because we're torturing somebody. It's because there's actually some work being done. All right, so give people a couple minutes. If they come on, we'll go ahead and continue to admit them. But again, my name is Chris Loehr. For you that are not familiar with me, I am the EVP and CTO for Solis Security. Solis Security based in Austin, Texas. I'm actually sitting at my home in San Antonio, Texas, about an hour south. And we are very, very pleased that you guys could join us today and listen to this great topic. We have multiple topics scheduled for this month, and this is our first one for National Cybersecurity Awareness Month. And so today we have joining us Spencer Pollock, and I will let Spencer introduce himself and give you a little bit of his background and what he does. And then once he does that, we will we'll get on with the show. So Spencer, you want to tell him a little bit about yourself?
Yeah, Chris, appreciate you having me, and I'm looking forward to the talk today. So I'm a cybersecurity attorney at a law firm in Baltimore called White, Taylor and Preston. I'm a partner there. Complete focus on cybersecurity, privacy, data breaches, ransomware, business email compromise, wire fraud. There we go. Regulatory compliance, HIPAA, GLBA, PCI DSS, all nerdy kind of things. I've been on the news a lot talking about these different topics. I've written a couple white papers, got published a bunch of quotes actually recently in the Wall Street Journal. And I am a huge nerd. I have a podcast. So I'm going to tell you all the name at the end, depending on how this goes, because I can't afford you all giving me bad ratings. So
that's right. There's one good podcast with me on it. So as long as you listen to that one, you're good.
That's right.
Thanks for that, Spencer. Yeah. And, we this can be interactive, so we have people monitoring. So if there's any questions or whatever, feel free to let us know. Obviously, we'll leave some time at the end for some questions. I hope people have questions because it's an important topic. And so this is just going to be a kind of Q&A between Spencer and myself. We don't have any boring PowerPoint slides or videos or anything like that. So sorry if you were looking forward to that. Well, we don't have it today. So we're going to kind of start off and I'll give you a little bit of background. Is the reason, and we'll have Spencer kind of get into details about this, but the reason we thought this topic is so important because in the incident response world, a lot has changed in the last few years. A couple years ago or a few years ago when we were working cases, a majority of the ransomware cases we saw were very simple, what we call automated ransomware cases, which means usually somebody received an email with an attachment or had a link or something, and they kicked something off inside their network that hit them with ransomware. And so the actual hacker, or what we term threat actor, was not actually in their environment, poking around, looking around, and trying to take things. So the script has flipped. And now we see Completely the opposite. So if we ever come across an automated attack, we're somewhat shocked. And the majority of the attacks today, whether it is ransomware, which we'll talk a little bit about, but we'll also talk about business email compromise, where the attackers are in there and they're doing more than just some minor stuff. And I know ransomware is never minor, but today it's just no longer about encrypting. So with that, Spencer, kind of give me your take on things and why you've seen things shift so much to needing legal pretty much on every case now, where maybe it was a little bit more optional a few years ago.
Yeah, I mean, I think you highlighted a couple really good points. A couple years ago, it was a lot more. That was automated attacks where you didn't have those exfil. I think HIPAA, you've always needed the legal side, but the majority of other industries, you really didn't. I say didn't, but it was a lot less necessary. I think one big thing we've seen is an increase in regulatory activity and involvement. I would say, in 2018, the last state, Alabama, got their data security notification law. So now every state in the U.S. has their own data security law. Obviously, you have industry-wide ones between HIPAA, GLBA. Now the insurance industry is coming out with their own PCI DSS with credit cards. And you've seen these different organizations basically having a race to see who can almost levy the harder fines and get a lot more involved. What's funny is that I just actually got an email before I got on here. I had a ransomware attack with Chris and his group back in, I don't know, I think March. Finished up, sent regulatory notices out to different regulators in April. I just got a letter from one of them 6 months later asking for a detailed explanation. So these regulators have really started to lean in. And I think the whole purpose behind it is that they started seeing these attacks as an existential threat, especially when data started getting taken and you get that double extortion from the encryption and the exfiltration. So what the law did, or laws and regulators and legislative representatives, was they started putting in different laws to catch up and then enforcing them. The problem with these laws is they literally just threw things against the wall. I mean, you saw in California with the CCPA how confusing that is. They don't define a lot of these different terms. They've now started allowing more private rights of action. So it was very much a rapid evolution that has been centered around ransomware.
Yeah, so talk about, like, in a lot of the cases, we work together on, and I'm sure outside of that, how many cases a day where it's only one state involved, right? We just don't see too many of them. So kind of talk about how you have to, you talked about all these different regulators and state attorneys general and so on and so forth, but just kind of talk about how this is a little bit more complex because you have to work with multiple parties, especially in today's remote employee type world we live in.
Yeah, I mean, I think the biggest issue that I see on a day-to-day basis, I mean, you highlighted one, the amount of regulators across a huge spectrum and kind of analyzing each of those laws to satisfy them. The other problem is with these regulators and these different laws is the unreasonableness in terms of timing. I mean, Chris, you can speak to how long forensics take a while. It's just how the nature of the beast. And then having to deal with these regulators, it's like almost calling customer service and who you get on the phone. I'll get a really good regulator in Massachusetts one day and I'll have to do it again the next day. And it's some angry person who probably just woke up on the wrong side of the bed. And it's just a rapid shift. And it's unfortunate because there's no uniform on how you're dealing with these people. And I think a lot of it comes from they don't understand cyber. They really don't get the security side and the technical side, but they also don't know, I don't think they understand the laws they wrote because it's a complex world and they really don't get the practical side. So when you're dealing with it on a day-to-day basis, it's really learning how to navigate and bob and weave with these different regulators. I've had Chris come on a lot of these calls with me because I found it, other lawyers take a different approach, where they don't want the forensic side on the calls with regulators. To me, I actually think it's a huge benefit because the regulators want to know about the forensic side. They really don't want to know about the legal side. They want to know all about the forensics. So having someone like Chris and his team and incorporating the forensics makes the legal side a lot easier because it's easier to satisfy regulators when they feel like you've done that due diligence. But once again, it's so state to state, regulator to regulator, which makes it a huge headache.
Yeah, I agree. I think, what we've been trying to tell people, and Spencer and I have a lot of conversations with people after the breach, right? To try to say, hey, look, you're not done. You might got to pass this one, but you got to do some stuff to step up to the plate and improve things. But the forensic stuff, it's amazing how much pressure is now put on the turnaround time with forensics, and it's not an automated process. I mean, it's a human being or human beings, depending on the size of the case, manually combing through files and log files and other types of forensic artifacts line by line by line, and trying to not only tell the story, get the facts put down on paper, but they also have to vet and make sure, because once they put that thing on paper in black and white, I mean, it's gospel. And so that takes some time, and you can't just bum rush this thing, because if you do, you say something wrong, or there's something something you put a date wrong or a time wrong or whatever. I mean, that can be extremely punitive. And so, I think, when we talk about, and I know there's some people on this call that are IT service providers, one of the things we're trying to stress to people is the more you have available up front, if you do have an attack, the more data you have up front for us to look at forensically, the better off we are. Because in today's world, most of the time we have to go through and use a tool to go manually collect data from systems, servers, workstations, whatever the case may be. We have to collect that data and do that. Well, in other particular cases, I have one that came in today where they actually have a logging platform set up, and so their logs are readily available. So instead of us having to take the time, because a lot of times in ransomware, your systems aren't even available for us to go collect from. But if you have stuff that's logged to a secure logging source, and we can pull those logs and start looking at them right away, that can trim down the time it takes to do the forensics and get you some answers more quickly. And Spencer's right. I mean, in today's world, we're dealing with, regulators, we're dealing with attorneys general, we're dealing with third parties that may have their own security teams that want to talk with you because you as a victim have some contractual obligation to detail what had happened with them, or they just might be an important customer or whatever the case may be, and we have to get on the phone with them. And so there's a lot of pressure, and it comes from all different directions. I mean, I think, when Spencer talks about who's, you got the people that wake up on a bad day that's really just to make a name for themselves. You have others that I guess are more reasonable. But I think, I think the one that always comes to mind for me is New York DFS.
Oh my God.
Talk to us about that, because I think if people understand what goes on there, and I don't want to brand them a worst case scenario, but possibly they are. That's really, if you can kind of prepare yourself for that, you can kind of prepare yourself for anything. So give us kind of what the New York DFS, guys, that's the Department of Financial Services for the state. They regulate the state banks and anybody that does financial services. You don't have to actually be in New York. You have to be conducting business there, and you can fall under New York DFS. So they've been doing a lot of this investigations type stuff for pretty much longer than anybody else. So Spencer, kind of walk us through some situations that you faced with New York TFS, because that's a pretty good horror story for the month of Halloween.
Yeah, I mean, this is even if it's recorded, I don't like the NOIDFS. I like some of the people are nice, but and I'm not getting political, but they are the classic example of big government. And what do I mean by that? They feel as though they should be in everybody's lives and everybody's businesses, that they have a right to, basically step through your front door, set up shop in your living room, and pick through everything. Now, I get it. If you live in New York, if you're based in New York, in terms of the jurisdictional part. Now, a lot of different regulators still try to think they have jurisdiction, but they enforce their state law. What New York has done now has basically said that we don't care where you are. We are the national cybersecurity enforcer, and we're going to enforce our law on you and different state law. I'll give you an example. And they also love to ambush people. I had a call with them a little while ago, and it was a good lesson learned. The person on the call was like, you know, we want to schedule another call with our team and your team. You don't even need to bring your forensic people. It's going to be very casual. Luckily, I did bring the forensic team, and it was actually members of Chris's team because it became very, very adversarial. I'll go with that. And they basically were trying to cross-examine my client and the forensic team about everything. And then we're demanding that we do more investigation, you know, data mining, notification. And my point to them was what they were asking was us to prove a negative, to basically prove that there was no access. Well, if there's no evidence of access, then how do we prove that there's no access? You know, they didn't care about that. They didn't care that there was no New York residents involved. The simple fact that my client was registered to do business there, they feel as though that now they can enforce different laws. And when I say they're intrusive, they are very, very intrusive. And they're not just bark, they do come with a bite. They've levied fines against organizations, mortgage companies, insurance agencies. Recently, it was a $1.2 million fine. And their consent order basically stated, well, you know, this involved Massachusetts residents or Vermont residents, and you only have to have access, not exfiltration. So those laws apply. Well, great. You don't have any right to enforce Massachusetts or Vermont law. The problem is nobody's challenged it. So if you imagine when things get challenged and they go to the appellate court and they maybe go to the Supreme Court, there's a new law precedent gets set there where the courts will review the statutory language and say, well, no, we don't agree that the department can do that. The issue is nobody wants to be in the forefront. Nobody wants to set precedent because even though the department would deny this, you as a lawyer, if you did that, they will blacklist you. And the next time you get in front of them, they will punish your client. But the other side of that is they're running wild on people. And it's very much disturbing. It's a disturbing trend. And I think they're not going to be the last ones that do this. Indiana likes to do it too. They're more confined to their state. Massachusetts likes to do it. Vermont likes to do it. The Northeast is definitely a problem child. They're having a race to see who's going to be the most kind of vicious and stringent. The problem is it's just going to keep continuing because in their minds, they're protecting consumers, but they are truly neglecting that they are hurting businesses. They're hurting small and mid-sized businesses. You know, a Target can take a hit, right? A Marriott can take a hit. Spencer's Widget Shop cannot take a hit. And God forbid if Spencer's Widget Shop doesn't have insurance, they can't take a hit. Small to mid-sized MSP, they can't take a big hit. So you're not really helping consumers. You're not helping people. You're just hurting. You're hurting everybody with this, in my mind.
Yeah, I remember one of the first cases we had. I think it was an insurance broker, and he had just a few clients that were in New York, and so we had gone through a process to. He had a single server full of stuff, and we'd gone through a process to just find the records that dealt with the New York residents, right? And we turned all that over and everything, and they came back and they're like, "No, we want all the data." And we're like, "What are you talking about?" "No, we want everybody, even people outside of New York." And you're like, well, just like you were talking about, Spencer, I mean, you can try to tell them no, or you could try to challenge it and go up the path. But that in the end, probably more expensive and more painful than just having to deal with their stuff. I mean, it's very similar when I was in the banking world. I know one of the issues we had as a bank was if regulators came in and found and said, had a finding, and if that finding was wrong, there was no appellate process. I mean, it was like, well, okay. I mean, what am I going to do? I just gotta take it, you know? And so it's very similar here. There may actually be a legal process to follow, but it's going to be prohibitively expensive, both from just a hard dollars perspective, but also just from your time perspective. And a lot of people, especially in SMBs, you know, you're one, two, maybe three people on a leadership team, and you have a year, 2, 3 years of your life that you can spare to kind of take on these issues, and it's really tough. I mean, I agree. We've had people that we've done work for, and they've had relationships with politicians at the federal level, and really tight relationships, and have tried to make some headway, you know, try to explain this stuff to them, and they just don't listen. It's not that big on their radar. I think it looks better headlines when they come down and hit people,
Yeah.
upside the head for breaches rather than look at really, the true issues. I remember a guy had said, well, heck, why is it my problem? I mean, so-and-so got hit, so-and-so got breached. Why am I the person that's also got to take the hit? And that's the other thing I wanted to ask you about, Spencer, because this comes up a lot, right? We get a lot of calls from people that said, hey, I just got notification that a third party that I use got compromised. And what are my responsibilities? Am I done? And usually the answer is no, because your data is your data. So can you kind of explain that, from a third party perspective, when somebody gets that notice, why legal is needed there as well?
Yeah. So let me give you a great example. We'll go back to 2014. 2014, there's a small HVAC AC company called Fazio, located in Pennsylvania. They're using free online, and don't get me wrong, Fazio is a very good company. I don't know them. They were never a client. I'm sure they're great, but smaller company, midsize, they're using free online anti-malware software. Obviously, that's not getting security patches. It's for individuals. So they get, phishing attack, bad actors get in, then they get admin credentials, password, and username to get into a payment portal. Then they get into Target. So Target started with Fazio. And if you think about it, nobody knows about Fazio, right? Nobody cares about Fazio. Once again, Fazio is probably a very nice company, but nobody really cares about them because I didn't give my information to Fazio. I gave my information to Target. So Target, I guess, could have thrown their hands up and been like, no, look, this was them. It's their fault. Similarly, if you think about that in a smaller context, let's just say you, I don't know, you've got an outside payroll company, right? Your employees give you the information, you push it out to payroll company gets hit. They send you a letter or they put you on notice and, you throw your hands up. You're like, well, sorry, employee X, like not me, it's them. I guarantee they're not going to care. The client's not going to care, employee's not going to care, government's not going to care because one, nobody gave them their information. They gave you it. So you instantly become the holder, the protector, right? And that's how they're going to look at you. All these laws put it on you. You can't just pass the buck. I guess contractually you could pass the buck up, but to start, reputationally, you're going to get slammed for that. The second part is, so under the law, in your contracts, and almost every state has this, and definitely the regulated industry. So HIPAA's got the business associate rule, GLBA's got the safeguard rule, and I'm telling you, every state law basically says, with an external vendor, if they've got access to your systems or you give information to, client, employee, whatnot, you've got to have a contractual provision, stating that you need to have reasonable safeguards in place. But I would suggest, because once again, you're responsible for the data that goes to that. But in terms of contracts, you got to take that step farther. Because if you imagine, I know there's MSPs on here, but let's just use an MSP as an example, because I'm sure every MSP on here are good people. You have MSPs though, just like you have lawyers, forensic security that are, less than good. And Chris and I actually have a couple like this, where the MSP was refusing to give passwords and there's a ransomware attack. We need to get into their systems, but we don't have admin credentials and they're refusing because whichever reason, they didn't get paid, they're about to get fired. And literally they are holding us. There's two people holding us hostage. There's the ransomware group and the external person. Then I get the contract. I'm looking at the contract. There's nothing in the contract that we can enforce this to get it back. There's nothing to hold the other company liable. So it goes beyond that though, because similarly, if you've got an external vendor, let's use the payroll company, they got your information, right? They get hit. I had one recently. It was a medical firm. The billing company got hit. The billing company would not cooperate with us. So I said, give me your contract. Pulled the contract. There's no provisions. There's no notification provision. There's no data disposal, indemnification. So if you think about it, if somebody has a breach, if there's not a contractual provision that says we've got to notify, that company X needs to notify client within 72 hours, they'll sit on it. And, to be forthright, I've got clients that we went through all their contracts and I'm like, we're not going out to anybody yet until we're ready. But the ones that have those tight clauses, we follow. And that's not underhanded. It's knowing what you know, knowing what you don't know. But the problem is on the other side, if you don't have that, you can't enforce it. So then you can't find out anything. Because once again, this all goes back to reasonableness. The law, your clients, employees, they're going to look at you if you don't have these contractual provisions or you're not doing due diligence and say, this is not reasonable. And I'm going off on a rant right now, but vendor due diligence to me is so big. And I'll put the legal part aside. If you don't if you don't open their hood and you're not looking into their systems, right, to ensure that they have the technical safeguards and something happens, let's just say they didn't have MFA or they didn't have updated firewalls. They didn't have employee training. Everything that, kind of someone like Chris would be checking into, I guarantee you're going to get someone like me on the other side who's going to be bringing a lawsuit and I will pick you apart. I would, because that's not difficult to have someone like Chris ask some of these simple questions and then look into it. And you can have it doesn't become cost prohibitive because you can limit the scope. But if you don't do it, I'm telling you, everybody on this call, if the one thing you're going to take away from me, vendors are an issue. They are. And MSPs on this call, to protect yourselves, you want to have tight contracts, really tight contracts with your clients. You want to limit your exposure in terms of liability and financial. If you've got a contract that has basically nothing in there, then you're going to be exposed for unlimited damages. If you've got one in there that says you can only get the total fees you paid, great. How many years have you been working with them? That adds up. Everybody else, if you don't do any due diligence and you don't have the contractual aspects, nobody's going to find this reasonable. It just won't.
Yeah, I mean, vendor management is something that we've been doing at Solis for a long time because it's been required by banks. That's where we cut our teeth, is with banks. I mean, we only did banks when we started over 18 years ago, and vendor management has always been at the top of the list. And it was a continuous process, right? And you risk ranked your vendors. And obviously, any vendors that had direct access to your network or any vendors that you gave data to, like confidential data, in our case, customer data, then you would, those would be critical. And then you would go on down the line. And the ones that were critical were the ones that you did due diligence on an ongoing basis. I mean, we have clients today that they have people show up on site. I mean, they schedule it, but they show up on site and they do a walkthrough for our site because we do security for them. And they have their customers are big banks. And so for them, they got to show that they're doing vendor due diligence to please, to meet the requirements that their customers are putting forth. But you're right, Spencer, it really has to be something that, when you wake up in the morning, you're like, man, I can't wait to get out there and do some vendor management. That's not, I know it's not the sexiest thing in the world, but at the same time, it is necessary, and you can't take anything for granted. Especially if your vendors go through some material change. Not to pick on service providers, but service providers sometimes, the good ones, and there's some great ones on this call. They have a very balanced portfolio of clients, right? So if they lose a client, it's not the end of the world. There are other service providers out there that have a bunch of little clients and one big breadwinner. And if that big breadwinner goes away, then that completely changes, everything about their business overnight. And they have to make some tough decisions about cost control and all that type of stuff. And so if you're not aware of those situations, and if you're not asking, at least on a quarterly basis of your MSP, certain vendor due diligence questions, then you're putting yourself at risk, because it really is your responsibility to do so. But even to get off of that, I mean, all your vendors are important. And I think the other thing I want to stress here is about the data is we've had quite a few cases where people are on the receiving end of data from a client, and then they get compromised, and thus that data whoever belongs to their client, that data was compromised. So not only do they have these legal issues, they got the normal regulatory stuff that we talk about all the time, but now they got to answer to their clients and whoever their clients bring on, attorneys, other IR firms, security people, whatever, and that can become a nightmare. But one of the things that almost happens every time is we find out that the data that is being sent to them is more than they need. And so one thing that I would say, whether you're receiving data or sending data, you need to be very cognizant of what's in that data, because a lot of times what happens is just some standard data feed, data extract, report, or whatever that just shoots out of the system, whatever line of business application they're using, and they just shoot it over. And sometimes you don't like, we deal with clients that they don't need to know patient information, but it gets included. So now it's a HIPAA issue. They don't need to know social security numbers or dates of birth. There's no reason for it, but it was included in the data feed. And a lot of times, not until they actually get compromised do they then realize, oh, we didn't even know that data was in there. We just get the data and take what we need. We never really paid attention to those other fields. And so in that particular case, it sucks for you because you're the one that was compromised and have to deal with that. But it's kind of a problem on both sides in the end. But legally, you're the one that got compromised, so you're the one that's going to be on the ugly end of that stick. So anyway, good stuff there. I appreciate that. I was trying to think about, the other thing I'd like you to touch upon, Spencer, is a lot of times people, we get into cases, we ask them if they have any confidential data, and they say no, and then we start asking them some more questions. So maybe you can kind of take us through maybe some other areas where you see people forget about other types of data that they may not even were thinking about is considered confidential or sensitive or something like that.
Everything. I mean,
Yeah.
literally, I feel like every time I get on a call with a client and I start with those questions, they're like, I don't have personal information. I don't have sensitive information. It's in this cloud, or it's in, it's with this provider, and I don't have any confidentiality agreements. I've got no notification agreements. And then I'm like, okay, great. I really hope that's the outcome. Go search your emails. Just do a cursory search. Go search Social Security. If you guys want to get scared, everybody on here, when you get off, go into your email account, or maybe have an employee, go search Social Security number, go search Social Security, driver's license, and see if that's in your email. If it is, delete it. Get rid of it, because I can't tell you how many people come back after they do a cursory search and they found a lot. The other part is in the contracts, what we're talking about. Sophisticated vendors are going to have those contractual provisions, and a lot of times the problem is it's encrypted and they don't have a backup. So there's no way for me to help them with that. Confidential information, NDAs. NDAs are very, very bad. Well, no, they're good, but in these situations, it's dangerous because nobody thinks about that. Even though I bring up an NDA, 3 days later they find out, and then we have to, open Pandora's box. So questions that you really need to ask yourself, and there's a lot of steps you can take in simple steps. Have a running list of things that are confidential, things that are sensitive, and where they're located, right? It will make your lives so much easier and less stressful. Because I guarantee if you don't, when I get involved, when Chris gets involved, and we start asking questions, you're going to spend the next, 90 hours probably of your life digging through any of your backups if they're there to find out what's in these servers, what's in your databases, what's in your emails. And the clients that have that, segregated where they know where it is, it just expedites everything, because then you'll get us the contracts, you'll get us your confidentiality agreements, and we can just kind of start knocking it out one by one. But it's such a problem talking to people because nobody thinks about it. Really, no, you just don't. This isn't a day-to-day thing. This isn't being conscious of walking down the street in a bad neighborhood where there's bad actors who might try to rob you, right? If you're in a bad neighborhood, you're kind of, on guard, you're vigilant. Well, people really need to shift their mentality. We're living in a bad neighborhood. I mean, Chris can touch on it more. I mean, if you think about it, there's no safe part of the internet, right? If you're not vigilant, you're gonna get yourself in trouble. And so people think, well, I don't need to track this information. I don't really need to care really where it is or if it's protected or not, because I'm not going to get hit. They don't care about me. I don't have that information. And then magically it happens and they need to care and they don't know where it is or what they have.
Yeah, it's the data management side of things is so important, especially when we talk about, and it falls in both categories in the ransomware where you have what we say data exfiltration, fancy term for your data gets stolen, and on the business email compromise side. So, I hear, people call us and say, oh, I think it's just a simple, one person's email was compromised, and we go, okay, well, what does that person do? Well, what did that person used to do? How long has that person been working there? And a lot of times you could find out that person's been working there for a long time and their mailbox is, 50, 50 gigs or even larger. We've had larger ones out there. email compromises, the majority of the time, the threat actor is sucking the whole thing down. And if you want to talk about a nightmare to go through, it's an e-discovery process on someone's mailbox. And it's an absolute nightmare. It's ridiculously expensive. It takes a lot of time and it freaks people out. And so getting ahead of this whole data management side is super, super important. I know most people I know have that kind of CYA mentality when it comes to email. Hey, you never know. I might need that email from 1998 about whatever. You don't need it. I mean, people need to be, people seems to be, uh, they need to kind of change their mindset around that and start to put in more retention policies and those type of things around email and kind of err more on that side of caution, because the data you have, and like we said, I mean, and Spencer, I've worked on a number of cases where not only do people have the data, they have copies of the data and more copies of the data, and they have it all over the place, and it's just ridiculous. Then you ask them, hey, why do you need that data? Well, we never know. You know, somebody might ask us a question about it. Well, I think you'll be better off telling somebody the story that says, look, we have a retention policy. I know because I've lived it. We have a retention policy in place we for security purposes, and we just don't have that data anymore. And you're going to get off. I mean, you're going to get off easier that way than you do when you have to explain why you're keeping years and years worth of emails or other data that just doesn't make any sense. And I mean, I've had a case where the IT staff was dead certain. They're like, no, all of our confidential information is stored on this application in the cloud. It's different set of usernames and credentials, and so we're good. And then we start looking around, poking around, and we talk to the threat actors, and the threat actors give us samples of patient data. And they're like, well, how the heck did they get that? Well, come to find out that one of their branch offices, they went into the application. Every time they would bring somebody in, a new patient, they would print that, they input the system, put it in the system, but they would go ahead and print that to a PDF and then store that on their file server. And they had like 50 or 60 locations. This was the only location that did it. And so then they had to understand why they did it, all that kind of stuff. And it goes back to the guy that ran that facility. He's been there for 30 years, and that's just the way he did things, and so on and so forth. You hear all those excuses, but you really have to be super vigilant about this stuff around data, because I will tell you 99 out of 100 times, it's going to bite you more than help you with keeping that stuff around, especially if it's not your data and data belongs to somebody else. If you actually have no responsibility to keep it, then you need to get rid of it, because it's going to be a tough time explaining it. So that's a good point. I'm going to bring up the chat. I see somebody had to leave early, so that was Michael. No big deal. I don't know. Does anybody have any questions for us right now? I mean, we're about 36 minutes in, 39 minutes actually. Anybody have any questions they want to ask us while we have Spencer on here? He's not going to bill you, so you may as well take advantage of it.
That's right. Free consults here.
Yeah, that's right. Yeah, I don't know. I think you can raise your hand, I believe, and I can unmute you if you want to talk. If you don't, then you can obviously put something in chat. I believe is how that works. So anyway, if not, we'll continue on. But if you do have a question, let us know. We'll be more than happy to answer those questions. I was trying to think about some other scenarios, and one of the things that came up is, and I know we could spend a whole day on this, but international. So let's talk about people that either do business outside the U.S. Or have offices or staff or whatever outside the U.S. What kind of impact does that have on a case?
Maria raised her hand. You want to take her question?
Yeah, sure. Let's see here. She raised her hand. Sure. Let me allow your mic, Maria. All right, Maria. Your mic is enabled, and you can talk if you take mute off.
Thank you. I work for a mid-sized broker agency, and I was curious if you could speak to the California regulators and your experience within California.
Yeah, they're a headache. They just are. I mean, California in general is a headache. In terms of, I guess it depends on the industry. In talking about the broker aspect, are you in the financial?
Insurance.
Okay, so California, and then it would depend if the CCPA applies for you, California Consumer Protection Act. Um, that makes things more of a headache. They are very big about the notification and trying to make sure that you've notified all the correct people. And a lot of questions I get from them is, why did it take so long? And why didn't you have more information about them? Why didn't you have the addresses? So I would say record keeping and a client list is very important when dealing with California to make sure you're buttoned up with that.
Thank you. Excellent advice.
Hey, no, great question. Great question. Yeah, so I being in Texas, I consider California a foreign country. So it brings that question back up. So kind of talk to me about the impacts that, kind of the international flavor can have on a particular case.
Yeah, I mean, that makes it a lot more of a headache because if you imagine, every different state law that you're dealing with and the different regulator laws here or regulations, expand that out, especially in Europe with the GDPR. The GDPR is a big headache. Now, I would say the regulators there are they're not really looking to hammer you. They actually do want to be helpful, but they have very tight time frames, 72-hour requirement. They have different regulators that you got to get to. And I found that the European side is the biggest headache. Kind of navigate the GDPR. I would say Canada's a headache with PIPEDA. Other countries have their own laws. I did this whole African country data protection booklet that I went through. I don't know. I went crazy one weekend and decided to look into all those laws. The regulators there's just not much regulation that's being actually enforced. They have laws in the books. And it's also the question, a lot of these different countries, if they're going to be able to enforce it, if you don't have a brick and mortar location. But once again, you don't want to be on the forefront. And if you become CCPA compliant, if you have those best practices, the likelihood that you're going to get hammered internationally decreases significantly. The other part is, though, a lot of times you might not have to notify, say, in Canada, but you're going to have to notify in the US or different countries. Then the question is kind of strategic. Well, if you have to notify in the US, but you don't have to do it in, say, California or Canada, are you really going to only notify the people in the US and not Canada? So then a lot of it becomes your business decision and more complex discussions internally.
Yeah, I can tell you that it's interesting about, well, I remember one of the earlier cases we had, it was, they had a office in the US and it was their main office. And then they had some satellite office in China and they were all in the same network. And I asked the question, I'm like, well, why are you all in the same network? And they were like, well, we have to exchange files with them. And I'm like, well, there's a whole better method to do that than put your networks together like that, because you're connected to China, you're hacked. I mean, there's nothing we can do about it, right? I mean, that's just the way of life there. And so I just really didn't understand that. And so I think everybody needs to keep that in mind. A lot of times we've seen where people, they want to keep staff and maybe staff move out of the country and they keep staff so that can have an impact. So I think if you don't recognize those legal risks up front, you need to, when those types of decisions get made, because there's a lot of impact there. Now I'll tell you, there's a silver lining to this as well. I know because we deal with a lot of cases in the U.S. and Canada, and in Canada, stuff is much more black and white there. So when we come down to, hey, is this something that has to be reported or whatever? It's very black and white. It's very rare where there's some gray area where they have to kind of wait it out or talk to somebody or anything like that. But in the U.S., just the way we were, and that's why we have so many attorneys like Spencer and all his buddies, that it's just a very litigious nation. And so that's just the way of the world. So things are not as black and white. And if we think like at a federal level, if there's going to be some overarching type federal regulation or laws that's going to be in place to dictate that. Now, there's a lot of conversation lately about this. I have all they keep talking about is notification there. So it kind of scares me. But I don't count on that happening anytime soon. So we're going to have to be dealing with this kind of menagerie of laws and regulations across different industries and states and all sorts of crazy stuff. We're not going to be as fortunate as some of these other countries that, again, things are very black and white about what it is, and it's very rare that sometimes I just remember one case that happened that I wasn't working on, but it came out across as an example in Canada where there was a little bit of a gray area. So what had happened was, and this is, this was an interesting breach, but it was it's publicized, but there was an organization for HIV positive people, and they would send newsletters out, and they would do that, and they would put people on the blind carbon copy the right way so people couldn't see the other recipients. Well, they err one time and they put everybody on the 2 line. So everybody could see everybody on the email. So what it came down to, as I understand it, is if the email address could accurately kind of identify you right away, like it was Spencer Pollock, whatever, then, that was an issue. If it was Blue Flamingo at yahoo.com, not as much. So, those are some aspects of things that people don't think about is, that's why you have to have kind of tight controls. And you have to be thinking about stuff. Hey, we're going to be sending out a newsletter. Do we make it so easy for somebody to accidentally put people on the wrong line when we send the emails out? So again, a lot of what Spencer and I talk to people about on an ongoing basis is having that privacy attorney alongside you outside of an incident so they can be cousin. So you could just say, hey, simply, hey, Spencer, we're thinking about doing this, or we're doing that, or we're going to change our policy about this, or hey, look, we've done all our business here, but now we're thinking about taking on a client in X part of the country, or hey, we're getting into the government space or whatever. Definitely having somebody that's very specific to privacy and security is ridiculously important. I mean, not to throw shade on people that have their general counsel or their attorney that they've dealt with, their general business attorney that they've dealt with for years. But this stuff, as you can tell, is it changes all the time. It's complex. I mean, Spencer, when he gets on calls, it doesn't matter if he worked the exact same thing the day before. Things have changed. So sometimes he's like, look, this is typically how it works, but I still have to go and I have to look into things to make sure that I'm giving you clear advice, because it's kind of crazy. I mean, there's things that based on your industry, about the size you are, about how many customer records you have versus you don't have, like CCPA, which was brought up earlier, it has some thresholds in there and it has some exceptions in there. And so none of the stuff is the same. And so it's always good to have that. And the last thing I want to talk about, because we have 11 minutes left, and I think a lot of people know this to a certain extent, but was Spencer, talk about attorney-client privilege and just how much important that is now, even compared to a few years ago with some more recent rulings by some higher courts about attorney-client privilege in IR firms and security companies and so on.
Mm-hmm. Yeah, and that's a great question. So just a little legal backdrop. There's 2 protections that clients get. Everyone knows about the attorney-client privilege, all the conversations we're having, all the notes I'm taking. But there's also one called the work product doctrine. Work product doctrine is basically when you have an agent of an attorney who's working at their behest, and the attorney is directing the investigation, what they're doing should be protected because it's in the anticipation of litigation. The court basically said that clients should feel comfortable that the investigation is going to be protected. The problem is in recent court decisions. So after a data breach, I'm brought in, I'll retain Chris on a client's behalf, so then everything they're doing should be protected. The problem is recently it's been challenged a lot in court, and a variety of courts have found that, well, no, it's not protected. Because one big reason is that clients have said, well, we didn't think there'd be litigation. So, I tell every one of my clients, if you don't think there's litigation coming, then you're missing the point. But the other part is they're like, well, you were going to need someone like Chris regardless. So why should that be protected? And it's a good point, but every time that you have this happen, I think a big thing to have discussions with, when I'm coming, the first thing I talk to clients about too is I operate in the apocalypse. The apocalypse is that you get sued with a class action, or that you get sued, right? So we're operating on the basis of litigation, anticipation of litigation. There's twofold for that. One, I truly believe that. Two, I would never say something I don't believe. So that's first. Two, we want to make sure the things that are being done are protected, because I just don't think the court actually understands how fast this moves. It's not a business purpose, right? Likely, Chris might have been brought in, but a lot of times when I come in first, then I bring them in. Or even if they got there, they're getting there from somewhere. And they're only there not to get, there's the remediation aspect, yes, but this is not a day-to-day thing. A day-to-day thing, they don't need Chris to come and put a fire out. They only need him there because they've been breached and they have that risk of liability. If you don't have risk of liability, why are you spending this amount of money to get back up and running, especially if you have backups? Why do you care about forensics at that point? You don't. You can go pay the ransom if you want, you try to get your data back, but I can guarantee you, every time I talk to a client, I'm like, we need this because of litigation. We need this because of forensics. And it's a problem with the court. It's a problem, once again, cyber in general. Nobody understands it. Outside of the industries that deal with it every day, everybody thinks it's just like normal things. It's the, slip and fall or the auto accident or contract dispute. And it's just not. And until the courts start getting their heads around that, unfortunately, companies are going to get the short end of the stick.
Yeah, we have a question from Simon. It says, we have clients who need to comply with GDPR, CCPA, Canada, et cetera, all the regulations. If one of their users asks for their account to be removed, what is the client's obligation to remove personal data from backups?
So I'm going to give you the lawyer answer. It depends. Depends on what their industry they're in. Different industries say that you have to keep it for a certain amount of years. So, for an attorney, I've got to keep your file, I think, for 5 years. Other industries are a little different. So if you're not in one of those regulated industries and somebody asks, get rid of it. Because under the California law, you need to, definitely. Under GDPR, you need to, because the whole purpose was that regulators wanted people to have more access to their information, to control their information better. If it's pretty simple information, like your name, your address, your email address, there's beyond the legal, there's just no reason to fight it. But once again, if you're in an industry that requires you to keep it, you got to be able to at least demonstrate that. And that's kind of a more in-depth conversation.
Great question, Simon. We're about, a little over 5 minutes left. Does anybody else have any questions? Anything else they want to ask? No. So only a couple of you get brownie points today. The rest of you, a little bit disappointed in your participation. No, we're happy that you're here. We appreciate everything that you guys do for us, if you're clients or partners. And we do, again, appreciate you coming on. And if you do have anything to follow up, feel free to reach out to us. If you, appreciate you, Wade, for showing up. If you have anything for us, let us know. We're always available, and I'm hoping that you don't call us for the really bad reasons where we have to get on the phone about an incident, because those are terrible. But we're definitely here to help you in answering your questions. So again, we'll leave with that. Enjoy the rest of your week. Enjoy the rest of your month. Hopefully you'll have a good time at Halloween. And we do have some more sessions coming up. So if you've signed up for those, I'll see you on at least on one of those. So again, appreciate it. And everyone have a great day. Thanks, Spencer.
Thanks, Chris.